So on the subject of bicycle accidents, I have recently been asked by someone who was involved in a collision. They were riding their bicycle and collided with a motor vehicle. And fault in this situation is kind of in dispute. The client or person inquiring about this particular case just said on the front end there was some dispute. Believe the vehicle's partially at fault, but they're kind of pointing the finger back, saying the bicyclist may have had some fault in that situation as well. The problem is the bicyclist was much more severely injured, which is very common in these types of scenarios. Common sense just tells us that a motor vehicle is a lot heavier, moves a lot faster, just is going to have more force than a person riding a bicycle. And so usually it's the bicyclist who ends up being more severely injured. Thank God in this situation the person wasn't killed. But on the question of whether that bicyclist has a claim, even though the other side may assert the bicyclist had some portion of fault in what happened, the answer is yes, absolutely. The injured bicyclist has a claim. In Mississippi, we have what's called pure comparative fault. Now, the rules for this, I have to say, vary significantly from state to state. So it is absolutely important and critical that if you have been injured in this type of scenario, you need an attorney to help walk you through that process. And you need an attorney who understands the law in the place where this happened or where the claim would be brought. Because the claim potentially could be brought places other than where the actual collision happened. For instance, it could be brought in the state where the defendant lives. But wherever that suit is being brought, it's going to be critical that the attorney representing you be aware of and understand the apportionment of fault rules in that state. Using Mississippi as an example, we have what is called pure comparative fault. Now, what that means is that when multiple parties are involved in an incident, in this instance, 2 people, but the same would hold true if there were 3 or 4 or 5. Ultimately, what a jury will decide is who is at fault and by what percentage. So for instance, in the scenario between the bicyclist and the car, if a jury decided, for instance, that the car was 100% at fault, then the car driver would be 100% responsible for the injuries to that bicyclist. But the way pure comparative fault works is take a scenario where the jury comes back and says, okay, the car was 75% at fault, but the bicyclist had some fault and is 25% responsible. In that scenario, under pure comparative fault, say if the bicyclist had $100,000 for the claim, well, the car would be responsible for $75,000 of that, or 75%. The bicyclist would have to take responsibility himself for the other, or herself for the other 25%, or $25,000. And those percentages would change depending on how they are. Now, one advantage under a pure comparative fault scenario is that some states, depending on their rules, the plaintiff, if they have a portion of fault, may be precluded, sometimes entirely, from a recovery. So for instance, there are scenarios in some states where if the bicyclist is just 1% or 5% at fault and the car is 99% or 95% at fault, the bicyclist cannot bring a claim. They would be barred because they help contribute to the collision. In other scenarios, the plaintiff can collect as long as that plaintiff, which would be the bicyclist, is less than 50% at fault. So as long as they were less than half at fault and the other party or parties combined were 50% or more at fault, then the plaintiff, in this scenario, the bicyclist, could bring a claim. But under a pure comparative fault situation, again, as I said, like we are in Mississippi, even in that scenario where, or even in a scenario where, say, the bicyclist is more than half at fault. So if the jury comes back and says the bicyclist is 75% at fault for causing this, but the car did something making them 25% at fault, then under that same scenario, even though the bicyclist is 75% at fault, if the total value of their claim is $100,000, they can still collect that $25,000, the 25% for their injury from the car, because the jury has decided that that's the apportionment of fault on the car, and under pure comparative, that car is liable for their portion of the damages to that bicyclist. So, it gets complicated in terms of trying to think through this and everything, but, for attorneys who do this on a regular basis, who litigate, who understand the local rules and laws governing apportionment, it is pretty straightforward. But that's why you need an attorney and why you need someone who is familiar not only with these types of claims, but also with that local venue where you're going to be filing suit. So my name is Brad Morris. I'm with Brad Morris Law Firm, PLLC. Just understand, if you've been injured in a scenario where you were riding a bicycle or a family member was and was hit by a motor vehicle, we're here to help. Just reach out to us by phone or through our website, and we will try to answer your questions and get you the help that you need. I appreciate you watching today.